It's truths. Haven't we heard that before? What do you think of U.S. courts? You must know by now. Defendant Brown, judge, did upon receipt of Bill and Celeste's motion for him to do so, recuse himself from the underlying bankruptcy proceedings on April 21st, 1997. We're up to 1977. It started in 1994, right? Yes, 1994, 1996, 97. The bankruptcy case and related adversary proceeding both were reassigned to the defendant, David S. Kennedy. Defendant David S. Kennedy is the predecessor judge to whom the bankruptcy case and the associated adversary proceeding were assigned upon defendant Brown's recusal. Although defendant Kennedy took no steps to address the questions raised by plaintiffs relative to the fact that the Antone Leone Trust and property of plaintiff's adult son are not part of the bankruptcy estate, David Kennedy, judge, prodded to do so by Montedenico trustee, unlawfully denied plaintiffs' rights guaranteed by the Fifth Amendment of the Constitution, causing plaintiffs to live with the very real threat of being held in contempt at defendant Kennedy's whim, the judge, because although defendant Kennedy ruled that plaintiffs could not exercise their Fifth Amendment rights relative to discovery, defendant Kennedy, the judge, refused and failed, even as of the date of this filing of this civil RICO case, to ever file a written order reflecting said ruling. The result, plaintiffs were denied their right to appeal said ruling to the district court, where it would undoubtedly have been overruled. Well, I really doubt that. Footnote. The reasons for the recusal motion are more fully set forth in the verified motion by defendant William W. Budrow and Celeste Leone Budrow. And I'll read that to you later. We are on page 20. During the same period of time, Montedenico trustee joined forces with defendants John L. Ryder, Stephen N. Douglas, and Apperson, Crump, Duzane, and Maxwell, thereafter Ryder, and the other defendants to create confusion and attempt to improperly force the sale of non-bankruptcy estate property located in Senatobia, Mississippi. Said property was known to all of these defendants to belong to one of the Antone Leone trusts. Ryder became the spearhead for the push to cause the improper sale of said property for the financial gain of the enterprise. Plaintiffs were forced to pay off Ryder in order to halt the looting of the Senatobia property. Plaintiffs brought this misbehavior to the attention of the United States District Court for the Western District of Tennessee by means of an interlocutory appeal, and then is still ignored as of the date of this filing. Subsequent motion to defendant David S. Kennedy for permission to file said interlocutory appeal. Instead of Bernice Bout Donald, Jed G. Weintraub, Monica Herring, Robert R. D. Trolio, Earlene M. Johnson, Wendy Warren, Earlene Greyer, Julia Smith Gibbons, James H. Allen, and others yet unknown, together with David S. Kennedy, judge, chose to conceal rather than correct the problem brought to their attention in violation of 18 U.S. Code Section 1503, obstruction of justice, and 18 U.S. Code Section 3, accessory after the fact. This is how putrid the situation in the courts has become since you have been robbed of your courts by these gangsters. This complaint is so well written. 80 characters in here, 80 cheaters, and it's all put together. How they were cheated. This is a civil RICO now, remember. A civil RICO. We are up to page 21. From the time the adversary proceeding 96-274 was filed by Montedenico, trustee, in 1996, Bill and Celeste Budrow, the plaintiffs, consulted with and relied upon the legal advice of defendants William C. Waller, Jr., Buchanan, Neville, and Stauffer, hereinafter Waller, Waller and Associates, who had represented plaintiffs in the past and held themselves and associates, including, but not limited to, Robert Orians, John Douglas, Martin, Tate, Morrow, and Marston, Craig M. Gino, Harris, Gino, and Dunbar, a.k.a. Holcomb and Dunbar, J. Ransdale Keene, and others, out to be trust law and/or bankruptcy law specialists, led plaintiffs to believe they would A. appear on behalf of William Christopher Boudreaux, that's the son, the one who inherited all the money, and the Antone Leone Trust, and that's the grandfather who had all the money, in the bankruptcy proceedings, and B. assist plaintiffs, their adult son, and the Antone Leone Trust in resolving the problems in the bankruptcy case and related adversary proceedings and take agreed upon actions. This is the third group of cheater lawyers. With a new presiding bankruptcy court judge in place, Montedenico continued his accelerated effort to loot the Antone Leone Trust. This accelerated effort included, but was not limited to, A, the aforementioned attempt to use Ryder to initiate the improper sale of non-bankruptcy estate property. B, he repeatedly filed notices of hearings and motions with certificates of service indicating they had been served upon plaintiffs, the Budrows, and knowing fully well that the plaintiffs were not being served. He arranged for numerous ex parte hearings, the result of which negatively impacted the Budrows personally and in the bankruptcy court. D, he swamped the court with even more perjurious affidavits, comfortable in the belief that plaintiffs would be unable to find counsel willing to stand up and fight the fraud, and that no one would pay serious attention to two pro se litigants. We're up to page 22. Okay, page 22. Defendant Kennedy, judge, looked the other way as Montedenico, U.S. trustee, attempted to blackmail plaintiffs, William and Celeste Budrow, and to make deals, quote unquote, with them, by and through Waller, J. Ransdell Keene, Craig Gino, Gino and Dunbar, Holcomb and Dunbar, and others, all of whom joined forces with Montedenico, trustee, for the benefit of the enterprise, civil RICO, to force plaintiffs, William and Celeste Budrow, to give in. At more than one point, Montedenico even went so far as to offer to drop the adversary proceeding if William and Celeste Budrow would agree to pay him off by selling the trust property located in Senatobia, Mississippi, and paying McManus personally $333,333.33 plus unknown other amounts to Montedenico, U.S. trustee, and the other defendant attorneys named herein. One attorney, upon hearing this scenario, was heard to remark, quote, "Guess the trustee was planning to retire on this case and buy himself an annuity," unquote. Plaintiffs wonder if Montedenico, U.S. trustee, has any concern about retiring with some emblems of honor. Now, this is extortion. That's what's part of a civil RICO, extortion. Light is too strong, but I need the light to read by this camera. I can see better than I can. The defendant, Kennedy, David S. Kennedy, judge, simply looked the other way as Montedenico, U.S. trustee, continued to mastermind the conspiracy, that's part of the civil RICO, to deprive William and Celeste Budrow of meaningful access to the courts and to provide their adult son and the Antone Leone Trust of property, all the while working to make misrepresentations to make it appear that the loss of said property is the fault of William and Celeste Budrow. At the recommendation of Waller, plaintiffs had sought the legal counsel of J. Ransdell Keene, fourth group of lawyers. Unknown to plaintiffs, Keene, a player known to Montedenico and Waller and others to have a reputation for, quote, rarely being sober enough to stand up in court, unquote, Keene filed an appearance but failed to name all of the parties he was hired to represent in his filings, and quickly crossed over to Montedenico's team, trying to convince William and Celeste Budrow that they should give in to Montedenico blackmail and have their adult son pay off Montedenico. Waller continued to promise to file an appearance and to file specific motions to have the non-debtor defendants named in the adversary proceeding dismissed from said proceedings, and the bankruptcy case filed by William and Celeste Budrow discharged, but instead continued not to do what he said he had agreed with William and Celeste Budrow to do. The defendant, David S. Kennedy, judge, continued in his laissez-faire mode and ignored the less than sober appearances and filings of defendant Keene. Now remember, this is the fourth crooked lawyer. Instead of addressing the problems brought on by having a less than sober attorney at the bar, the defendant, David S. Kennedy, judge, became even more intent on threatening plaintiffs with contempt of court for standing on their Fifth Amendment rights under the Constitution. Montedenico, U.S. trustee, and David Kennedy, U.S. judge, bankruptcy judge, used the threat of contempt against plaintiffs in hopes that they would cause their adult son to pay off Montedenico trustee. The conduct in which they engage, intimidation of a witness, violates Title 18 U.S. Code Section 1512. Good one to remember. Do you know that this remote will zoom? Isn't that great? Amazing. Still unaware of Keene's real handicap, plaintiffs recognized that Keene was not accomplishing anything and that the court was still ignoring the fact that the trust and their adult son's property was simply not part of the bankruptcy estate. Again guided by Waller, plaintiffs consulted with defendant Robert Orians and Martin, Tate, Morrow, and Marston. Fifth group of useless lawyers who wasted a great deal of precious time and ultimately failed to even file the appearances and motions they had misled plaintiffs into believing that they would file. Waller still took no action. We are on page 24. Still guided by Waller, plaintiffs retained the services of yet another bankruptcy trust expert, number 6, defendant Craig M. Gino, and the firm of Harris, Gino and Dunbar, Holcomb and Dunbar. Gino met with plaintiffs and laid out an impressive plan to sweep into the bankruptcy court, have the trust and their adult son and his property dismissed from the adversary proceedings, and then to have the entire matter closed. Waller was to appear on behalf of plaintiff's adult son. Gino was to appear on behalf of plaintiff's Celeste Leone Budrow and in her capacity as trustee. Plaintiffs waited for months. The filings Gino promised were never made. Six group of hoods. Plaintiffs traveled to Gino's offices and presented him with copies of 36 checks and trust documents proving that the trust property and their adult son's corporate and personal property were property in which plaintiffs had no personal interest. Gino promised to immediately bring this evidence to the attention of the court. Gino still did nothing. Waller still failed to file an appearance and also did nothing. 6 group of cheaters. More months went by, filing dates were at hand. Gino still had not filed the motions plaintiffs had instructed him to file. At the last minute, instead of filing motions to end the travesty, Gino and Waller, in a thinly veiled attempt to force the Budrows to give in and their adult son to pay off Montedenico, McManus, and others, threatened to bring suit against plaintiffs if they would not agree to have their adult son sell the Senatobia, Mississippi property and pay McManus the $333,333.33. The payoff. He wanted to drop the adversary proceeding as well as unknown amounts to all other attorneys involved. These people were called by God. The Budrows were called by God. Waller finally did file an appearance. Days prior to said filing, Waller had misrepresented to the Budrows that he would appear on behalf of their adult son and asked that he personally be appointed as a guardian ad litem to ensure that the trust property would be protected for plaintiff's son. Instead, Waller filed a motion for the appointment of a court-appointed guardian ad litem and joined in Gino's threats. Waller threatened to seek the appointment of a permanent guardian ad litem and to remove Celeste Leone Budrow as her adult son's natural guardian and to have her discharged as trustee of the trust her father had established for her adult son unless plaintiffs would agree to Montedenico's demands, which was to hand over the $333,000 property in Mississippi to them. Civil RICO. Extortion, enterprise, conspiracy, predicate acts, money. Once the misconduct of Montedenico U.S. trustee was brought to the attention of the defendant, David S. Kennedy Judge, Kennedy Judge then chose to conceal rather than correct the problem he inherited, along with inheriting Montedenico from the wholly incompetent William Houston Brown, another judge, in violation of 18 U.S. Code Section 1503, obstruction of justice, and 18 U.S. Code Section 3, accessory after the fact. Given the complexity of the scheme to loot the Antone Leone Trust and other inheritance of William C. Budrow, and to point the blame on said losses at the plaintiffs, William and Celeste Budrow, and the mountains of evidence of judicial misconduct by the defendant bankruptcy court and district court judges, as well as the misbehavior of the defendant attorneys, plaintiffs have endeavored to isolate each defendant and describe his or her actions infra in order to comply with Federal Rules of Civil Procedure 81. As a result of the misbehavior and carefully planned ongoing schemes of Montedenico U.S. trustee and the other defendants herein named, on August 13, 1999, now this started out in 1994, and here we are in 1999. Look what those people have been through. Defendant David S. Kennedy, judge, assisted Montanico, U.S. trustee, in blocking plaintiffs' access to the bankruptcy court. He did this by misrepresenting to the Budrows earlier that the Budrows could appear by telephone, and then knowing that the court's telephone equipment was not functioning, by proceeding with an ex parte proceeding that culminated in all of the trust property belonging to the plaintiff's adult son, Christopher, and or to the subject trusts being unlawfully declared part of the bankruptcy estate and turned over to Montanico for the benefit of the enterprise, of the benefit of the civil RICO. Defendant, the Honorable William Houston Brown. William and Celeste Budrow became aware of the deteriorating mental condition of defendant Brown, the judge, during his tirade against them in open court and his open threats as addressed with more specificity in the affidavit of William Budrow, which I'm reading you later, filed in support for his motion for recusal. A copy of which is attached here to Exhibit A and adapted as though fully set forth herein. On reflection, William and Celeste Budrow can recall defendant Brown, judge, staring off into space, losing his train of thought, pounding his fist on his bench, ridiculing plaintiffs, and engaging in other behavior normally engaged in by those who are not paying attention or who are not all there. Once the threats to request criminal investigations against plaintiffs were openly made by the defendant, the Honorable William Houston Brown, judge, in open court, the defendants, the U.S. attorney and or unknown members of his or her staff, as well as unknown IRS agents, were physically present in the courtroom whenever any proceedings were had on the bankruptcy case. The purpose, to clearly threaten and intimidate plaintiffs in hopes of successfully stopping plaintiffs from pursuing their rights in the courts. See, they're there with the threat of arresting them, and that happened. They did arrest them. The mistakes of law by defendant the William Houston Brown, judge, in both Budrow's bankruptcy case and the adversary proceeding relative to said case, while legion, are not addressed here. What is addressed by plaintiff's complaint herein, and in the motion for Brown's recusal, filed in the underlying adversary proceeding and adapted as though fully set forth herein, is the apparent total lack of ability to perform the judicial function by defendant Judge William Houston Brown. Now that we are on page 27, and I'll read you the rest of this. Hello folks, I believe the last videotaped report to you was done on Thursday, March the 22nd. Today is Monday, March the 26th. A lot has happened to report. It is obvious that defendants William Houston Brown, the judge, and his successor, David S. Kennedy, flip-flop according to the positions taken by the trustee, the U.S. bankruptcy trustee, Montanico. You can see that Montanico saw all this money, and he was just out to go. At present, defendant appears to be sandbagging orders and condoning the misbehavior of U.S. bankruptcy trustee Montanico, who is not providing sufficient notice of hearings or timely copies of orders in hopes that the plaintiffs will either miss their opportunity to appeal or miss key hearings. Is this crooked or isn't it, folks? Let's see, this is March 16th, the day before St. Patrick's Day, and we're marking down that we've read it on TV to you. It also appears that defendant David S. Kennedy, judge, is ashamed to let his behavior in court be exposed to the public at large via verbatim court transcripts, as the Budrows are informed by the court reporter that not only were the telephones not functioning for the August 13, 1999 proceedings, the Budrows were, at the last minute, prevented from attending, but in addition, the electronic recording equipment was not functioning either. The result is what? An hour and a half hearing is missing more than half of the official record. Is that crooked, or isn't it, folks? Can you believe that United States courts are this crooked? Can you believe that your courts have been stolen from you and they're in the hands of gangsters like these people? That pro se litigants, Budrow, are denied meaningful access to the courts in their complaints, appeals, and petitions due to their adjudication by defendant unknown Sixth Circuit Court of Appeals law clerks, staff attorneys, or court clerks instead of Article III judges is common knowledge among the legal fraternity. It may be common knowledge, but they're not going to get away with it. You have a constitutional right, the Budrows have a constitutional right to an Article III judge. The term society of losers, quote unquote, is what the federal courts think of pro se litigants. Well, we're just going to change their so-called pea-brain minds. This was quoted in the misunderstood pro se litigant, more than a pawn in the game. 41 Brooklyn Law Review, 769. And I wouldn't trust anything that comes out of the Brooklyn Law School, or it comes out of Brooklyn, or it comes out of the Eastern District of New York. We are on page 28 of 33. An article entitled When Prisoners Sue, a Study of the Prisoners Section 1983, Suits in the Federal Courts by William Bennett Turner, 92 Harvard Law Review, showed the results of the examination of 5 federal districts and 664 cases filed by pro se litigants in those districts. Isn't this interesting? The districts that were the subject of the study were the District of Massachusetts, hopelessly corrupt, the Eastern District of Virginia, the District of Vermont, the Northern District of California, and the Eastern District of California. The disdain of pro se litigants by court personnel and the manner in which pro se filings are handled were wholly confirmed. In all 5 districts, there was a screening process of all pro se cases by someone other than a judge. Strictly against the statutes, strictly against the Constitution. There was no screening on the merits and only added to the backlog of cases. Quote, there was no way of identifying meritorious cases for prompt detention, unquote. Before 1977, in the Virginia district, the screening of informant pauperous cases was performed by a magistrate, a law clerk, or judge, depending on the judge's preference. In 1977, a writ clerk, quote unquote, took care of these functions. The standards used by this clerk, directly out of law school and without guidance or training, were at the time not clear. 2 weeks in the job, the writ clerk was of the opinion that most, quote unquote, of the prisoner cases are frivolous and there is much lying, quote unquote. Indeed there is, by judges, by magistrates, by clerks. This is from an interview with Joseph Vespoli, writ clerk in the Eastern District of Virginia. This train of thinking carries over to most pro se cases whether filed by a prisoner or someone on the outside. Now let us make a copy of that and let us send that to the Delaware court. Here it is. We will send this to the United States District Court, the District of Delaware. In Glendora versus Charles F. Dolan. In summing up his study, Professor Turner made this observation, quote, "It is apparent that it is futile for prisoners to proceed pro se. Don't you believe it, and don't you give up. Not only is it unlikely that their complaints will service the ex parte section 1915D screening, but even assuming that the cases are not dismissed prior to service, they will languish on the court's dockets. They are prime candidates for dismissal for failure to prosecute." Unquote. Plaintiffs are certain their carefully researched pro se bankruptcy filings have been equally ignored and assumed to be lies. Well, they just can't get away with that. Okay? There is something left of the United States of America that these gangsters haven't chewed up already. We're on page 29 of 33. Later in his conclusion, Professor Turner remarked, quote, "Pro se litigation deserves both the interest in efficient judicial administration and the need to do justice in individual cases, as the suits crowd the court's calendar and require court action, but rarely are adjudicated on the merits. Since our study made no attempt to evaluate the merits of individual complaints and compare their disposition, it is not known whether justice was in fact done in individual cases." Okay, let us copy that too and send it to Delaware. This was written by William H. Brown. When this complaint was sent to me, I felt compelled to reveal it to you. Forced by the improper actions and inactions of the attorneys they hired to represent themselves pro se, the Budrows are certain that none of their submissions ever were judged on the merits. I agree with them. Mine weren't either, with a few exceptions. Seeking justice in the aforementioned situation on September 22, 1999, plaintiffs filed in the United States District Court for the Western District of Tennessee a civil complaint, Budrow versus Montedonico, paid their filing fee, and presented properly formatted and prepared summonses to the clerk of said court for issuance in accordance with Federal Rules of Civil Procedure, including but not limited to Rules 3 and 4. The Budrows, the plaintiffs, were informed by court staff that simply because they are pro se litigants, the Sixth Circuit courts do not believe they have the right to proceed and have their case handled by an Article III judge as provided by the Constitution. That instead, there are especially designed pro se staff attorneys who decide whether or not summonses will be issued in their case. Attached here too, an exhibit attached here too, and incorporated as though fully set forth herein a copy of Administrator Order number 9810, rule titled "In Reissuance of Service and Non-Prisoner Paid Pro Se Complaints," dated May 30th, 1998, and rendered by defendant Julia Smith Gibbons. She's the lead defendant in this case. Plaintiffs, the Budrows, were told that said pro se staff attorneys would determine if their complaint was valid, and that only if these fresh out of law school staff attorneys determined that plaintiff's case was valid, would summonses be issued. Defendant trustee, the judges, the unknown staff attorneys, plaintiffs, Budrose, Donico, and he just couldn't resist his greedy fingers from it. He had to sell everything in his heart and everything in his mind and everything in his soul to try to get a hold of that money. We're on page 30 of 35. Legal claims. First cause of action. This court has recognized that a defendant has a right to a tribunal both impartial and mentally competent to afford a hearing. Second cause of action. The obstruction of justice conspiracy engaged in by the defendants consists of predicate acts in violation of 18 U.S. Code Section 1503A, obstruction of justice. Remember that. 18 is the criminal code, okay? Title 18 is the criminal code. And obstruction of justice. And 18 U.S. Code Section 1512B1, intimidation of witnesses. 1503, obstruction of justice. 1512, intimidation of witnesses. The predicate acts described herein over the time span describe a RICO conspiracy. RICO, racketeering, influence, crime, organization, and that's what this court is. It's a crime organization. A United States District Court is a crime organization. Concealing a document is an act in violation of the obstruction of justice statute. The defendant, trustee, judges, unknown staff attorneys, unknown law clerks, and unknown court clerks, and unknown IRS agents have concealed key material exhibits that prove beyond a doubt, and we are on page 31 of 35, that the trust, corporation, and property of the adult son of the plaintiffs, that's William Christopher Boudreaux, are not part of the bankruptcy estate in the underlying case. In other words, the Boudreaux went bankrupt, and they went to the bankruptcy court. And then the crooks in the court found out about Celeste Boudreaux. She was the trustee for her son's estate, left to her son by her father, Antone, A-N-T-O-N-E, Leone, who was a very successful wrestler and made a great deal of money. And the grandfather, Leone, left this money in trust for his only grandson, Christopher, the son of Celeste and Bill Budrow. And they saw that money, and they had to have it. They had to steal it, by hook or crook, by both of them. Procedures such as those engaged in by defendant trustee judges, unknown staff attorneys, unknown law clerks, and unknown court clerks deny citizens their right of access to the courts. Access to the courts must be adequate, effective, and meaningful. Such procedures as those engaged in by defendant trustee, the judges, the unknown staff attorneys, unknown law clerks, and unknown court clerks deny citizens their right to petition their government for the redress of grievances. Filing a complaint in court is a form of petitioning activity. A pattern for RICO purposes consists of at least two related predicate acts of racketeering activity that together constitute a continuing course of fraudulent conduct. And this is what we have seen in the Eastern District of New York. This is what we have seen, you and I, in the Southern District of New York. And here it is in the Western District of Tennessee. The enterprise. The enterprise described herein includes individuals employed by the executive and judicial branches of the federal government and members of various state bar associations who are considered, quote, officers of the court, unquote. They all are associated in fact, though not a legal entity, apparently organized for the purpose of concealing the mental disabilities of defendant, Judge William Houston Brown, and looting, and that's exactly what they're trying to do, property from innocent parties for the benefit of the enterprise as a whole, as well as the individuals comprising said enterprise. And the civil recall is 18 United States Code 1964. Now we're up to page 32 of 35. Defendants Judge William Houston Brown and Judge David S. Kennedy, these crooked bankruptcy judges, demonstrated that just the presence in the courtroom of an assistant United States attorney can be not only a threat, but a, quote, spear in the hands of ambitious prosecutors anxious to silence dissent or to climb to greater political heights over the backs of hapless defendants caught up in the system. That's a quote from Abuzik, The Inquisition Revisited. Hey, good. The behavior of Judge William Houston Brown and David S. Kennedy in threatening plaintiffs simply because they elected to stand on their Fifth Amendment rights is nothing new. Instances sometimes occur in which ministerial officers take such liberties in endeavoring to discover and punish offenders as are even more criminal than the offenses they seek to punish. Cooley, constitutional limitations. Now the RICO conspiracy. As the facts of this case plainly illustrate, the defendants have engaged in numerous violation of 18 U.S. Code sections 1503, what is that one? What is it? Obstruction of justice. And 1512, what's that? Intimidation of witnesses. In order to further the goals of the conspiracy. See U.S. Code, this is the Civil RICO, section 1962 C and D. As the facts pleaded herein clearly show, defendant Judge William Houston Brown is not competent to be a federal bankruptcy judge. Defendants Edward L. Montedonico, this is the U.S. trustee, and I've met a few of those who are extremely dishonest, is not functioning as Chapter 7 trustee. He is functioning as a legal terrorist. It is the duty of this court to protect society from this amoral, unethical, and criminal United States bankruptcy trustee. Every day that he remains in office, innocent people are in danger of being railroaded out of exempt property via perjured testimony and intimidation. How many more innocent people will wind up in the streets due to the Machiavellian tactics of this moral pit viper? That is Edward L. Montedonico, Western District of Tennessee. New people moved in next door, and they have a puppy. I'm doing everything I can for that puppy. I just took him some water. I just took him something to eat. I unleashed him the way I found him so he could run free in the yard, fenced-in yard. But he's his own worst enemy. He's going to get arrested. He's going to get taken to jail, and he's going to get murdered. And I've been trying to help that dog for 2 weeks now. He's his own worst enemy. Back to the Budrows. The actions of the defendant federal judges at both the district court and bankruptcy court levels are actionable under Title 42 U.S. Code Section 1985-2. That's conspiracy. As are the actions of defendants, United States Attorney, Assistant United States Attorney, IRS agents, and the bankruptcy trustee. Indeed they are. It's all a civil RICO, and it's all conspiracy. Fourth cause of action, Federal Rule of Criminal Procedure 3. There are some published opinions that hold that only a federal prosecutor can bring a criminal complaint. This is not the way the rule reads. Rule 3, the complaint. The complaint is a written statement of the essential facts constituting the offense charged. It shall be made upon each before a magistrate judge. It shall be made upon oath before a magistrate judge. And I had no oath, and Franklin and I had no oath in the crooked Eastern District of New York civil RICO with Bruiser Ken, the lying brute who went berserk and beat us up in the Uniondale courthouse, and then lied that we touched him, and we did not. The plaintiffs Budrows in this action, William W. Budrow and Celeste Leone Budrow, have the same right to file a written complaint on oath before a magistrate concerning the criminal acts of the defendants in this action as any BATF, FBI, or DEA agent does. The grand jury can insist upon the production of every person's testimony, unless, of course, the grand jury is kept in the dark, quote unquote, in violation of Title 18 U.S. Code Section 4. By those whose duty it is to report crimes. Relief requested that defendant, Judge William Houston Brown, be adjudged mentally incompetent after a mental and physical exam pursuant to the provisions of Federal Rules of Civil Procedure 35A. We are on page 34 of 35. Let me know, read on TV, March 16th, 2001, and it's a beautiful day. Do you know that the temperatures in the 30s may just about be over? Certainly temperatures in the 20s may just about be over. And certainly temperatures in the teens and maybe snow is over. The defendants, Montedonico, the United States trustee, McManus, Fulton, Virgos, and others, on the U.S. bankruptcy trustee staff, that they be removed or suspended from their duties immediately, pursuant to Title 18 U.S. Code, Section 1964A, the Civil RICO. That a grand jury be convened pursuant to Federal Rule of Criminal Procedure 6A, see the United States versus Christian, in order to investigate the depredations complained of herein. That a special prosecutor be appointed from outside the 6th Judicial Circuit. Remember, this is in the Western District of Tennessee. That this court issue a declaratory judgment pursuant 28 U.S. Code Section 2201 that plaintiffs in this action, William W. Budrow and Celeste Leone Budrow, have the same rights under Federal Rule of Criminal Procedure, Rule 3, that defendant in this action, Edward L. Montedanico and William Houston Brown, a U.S. trustee and a judge, had when they filed the criminal complaints against these plaintiffs that have caused the U.S. Attorney and the IRS to be a threatening presence at every hearing in the underlying bankruptcy proceedings. Did I tell you before, this is a police state, and these people are also in violation of Article 4, Section 4 of the Constitution, that the Budrows have, and you have, an undeniable right to a Republican form of government. What was the Revolutionary War all about if this is what we're ending up with? That this court issue a declaratory judgment pursuant 28 U.S. Code Section 2201 that plaintiffs in this action, William W. Budrow and Celeste Leone Budrow, have the same rights under Article 3 of the Constitution. That this court enjoin the named defendants herein from proceeding with the looting of non-bankruptcy estate property belonging to valid trusts in which the plaintiffs have no personal interest, pursuant to 28 U.S. Code Section 2201 and 2202. Such other relief as this court deems just, proper, and equitable. That the defendants, the Budrows, have the same rights under Article 3 of the Constitution to have their case adjudicated and presided over by an Article 3 judge, and that the Administrative Order 9810 of the United States District Court for the Western District of Tennessee, attached hereto as Exhibit P001, and incorporated as though fully set forth herein, is unconstitutional on its face, and that's that a pro se litigant doesn't get an Article 3 judge. Well, boy, I don't let them get away with that. I'm sure the Budrows won't either. And let me show you their signatures. Now, I don't say how they can say respectfully to submitted because there isn't anything there to respect. You have to get our respect. These courts have to get your respect and my respect. How? In the old-fashioned way, they've got to earn it. Okay. That's enough for today. I'm going to try to call Memphis now, Memphis Public Access, and get a chat with this all happened, and get a chat with Glendora on there, and expose this crookedness of the United States Court in the Western District of Tennessee. Expose that in Memphis. This is a beautifully pleaded complaint. Can you imagine what these people have been through for 5 years? Okay. United States Bankruptcy Court, Western District of Tennessee, Western Division, in re William W. Budrow, Celeste Leone Budrow, debtors, versus, oh no, this is a adversary proceeding brought by a crooked U.S. trustee, bankruptcy trustee, named Edward L. Montadonico against William Budrow and Celeste. And this is the affidavit of William W. Budrow, State of Mississippi, County of Tate. And let me give you the date. See, I always put dates at the top page, top of the first page. Oh, that's awful. This is the case of Budrow versus Gibbons. Gibbons is a United States District Judge. Okay. Before me, the undersigned authority, personally appeared William W. Budrow, who deposes and states as follows: I am a defendant debtor in the above captioned matter, and I do have personal knowledge of the facts stated herein. I am filing this affidavit pursuant to 28 U.S.C.A. sections 144 and 455 to demand that William H. Brown disqualify himself from presiding over any and all proceedings in this action on the grounds that he has personal bias and prejudice against me and a personal bias on behalf of the trustee plaintiff so pervasive that I have been and continue to be denied even the basic 14th Amendment right to due process of law. Very well stated, isn't it? And this is against Edward Montadonico, a crooked U.S. bankruptcy trustee. I hereby certify that this affidavit and corresponding application are made by me in good faith. During a proceeding in the court of Judge William H. Brown on February 15, 1996, Judge Brown repeatedly made it abundantly clear that he has a personal bias and prejudice against both myself and my wife, Celeste Leone Budrow. The personal bias and prejudice emanates from the judge's personal beliefs and lifestyle, and not from his participation in the above captioned matter. This bias arises out of the judge's personal background and the personal beliefs as he himself has stated. Hold still, I gotta go get a better light. Con Edison some more money. Responding to information that my wife and I received monies from a family trust that is not income, the judge found it necessary to comment, quote, "It is not a lifestyle that I have lived," unquote. See February 15, 1996 transcript, a copy of which is filed herewith, page 155, line 3. 2. Responding to my beliefs regarding income taxes, page 159, line 19, through page 160, line 7, same transcript. The judge says, "Mr. Budrow, I have been around quite a while. I have heard this before, and I have seen a lot of tax protesters. I have seen a lot of people that don't believe in paying taxes. And I have to tell you that I think they are wrong. I think the law requires you to file tax returns. And the way I read the law, there is not really any question about that. And the way I read the law, you have an obligation to do what the law says until some court tells you you don't have to." Judge Brown became even more arrogant and sarcastic with me when I explained the details of the family trust and the fact that I have not personally owned any property for over 40 years. The court: but you sure drive a car, and you sure live in a nice house. Budrow: that's right. Judge: and that is to your benefit, isn't it, Mr. Budrow? When I attempted to explain to an enraged Judge Brown that the attorney I had hired, who had not asked me for any money down, had been negligent in his representation, and that was now M.S. Sawyer obtained a judgment against me, Judge Brown's sarcasm and arrogance toward me came from a clearly biased, less than impartial man. Quote: Judge, you get what you pay for, Mr. Budrow, and today you are getting exactly what you paid for. Zero. In response to my attempt to ignore the judge's rage and continue on with my explanation of how the attorneys we filed in Memphis knew that we didn't own property in Tennessee and knew we had no creditors in Tennessee, yet improperly filed this bankruptcy case in Tennessee anyway, Judge Brown admitted that he could have granted the motion to transfer the case to the proper jurisdiction, but chose not to. Quote: well, the reason I really did that, Mr. Budrow and Mrs. Budrow and everybody, is it was too late in the case to change the venue. The statute provides that if the venue is wrong, that the court should change the case to the right venue, transfer it to the Northern District of Mississippi, or dismiss the case. But at that state, we already had this adversary proceeding and the other one that was filed by someone I have forgotten. There was some, and that's cut off, end of quote. You want to know why he didn't transfer it? Because he saw the money. He saw the money in the trust. Thousands, hundreds of thousands of dollars in the trust. And then he tried to make the trust part of the bankruptcy, which was a cheat. That's why he didn't transfer it. They were sticking and holding on to it to try to get that money out of the trust. And they're still trying to get it out 5 years later. Judge Brown never did provide a legal reason for ignoring the statute and denying the motion to move the bankruptcy case out of his court. The remainder of the February 15, 1996 transcript clearly evidences an out-of-control, unable to be impartial Judge Brown taking out his personal convictions against the lifestyle my wife and I lead with more than an hour-long diatribe against us. Judge Brown holds such a pervasive animus against us that he prevented my wife and not me from possibly settling the claim of creditor Mona Sawyer by me and never giving me a chance to present our proposal to his court. We had just returned from a lunch break. Mr. Higgs, the creditor's attorney. Your Honor, I think Mr. Budrow wants to address the court. The court. Oh, sure. Mr. Budrow. Well, Mr. Higgs and ourselves were talking in the back about different things and so forth, and he proposed maybe that if we were willing to withdraw his client's claim and let everything something. But that was all I was able to say. Judge Brown thundered down at me, "It's too late. Note, a short while later, he would indicate that it was not at all too late when he threatened to transfer the case to Connecticut. Judge Brown, knowing full well it was not too late for us to reach a settlement with this creditor, stopped any possibility of settlement cold, and because of his personal hatred that had clearly turned into a vendetta against us, prevented us from even discussing settlement. Why didn't the judge want the case settled? For the reason I told you. They wanted to see if they couldn't get that money. And Rusty Dog has tilted the tripod, so let me see if I can get it straight. So again, why didn't the judge want the case settled? Because he wanted that money in the trust. Judge Brown completely lost all patience and ended the hearing without even giving opposing counsel an opportunity to cross-examine me. See? Oh, he's getting so nervous that he's not going to get that money, said Mr. Budrow. The Internal Revenue Code has not been held unconstitutional by the Supreme Court of this country. It has been held constitutional by the Supreme Court of this country. Now, you may disagree with the Supreme Court of this country, and that's your right, but that doesn't mean you have a right to disagree and to violate the law. Apparently, Judge Brown says I'm going to write a letter to the United States Attorney across the street, and they have the authority, if they choose to do so, to investigate you for criminal violations. Do you understand that? Gotta get that money. By hook or crook. That judge has got to get that money. On page 163 of the same transcript, after I explained to Judge Brown that the IRS had conducted criminal evasions relative to my non-payment of income taxes 6 times in the past 40 years, and that all 6 times the IRS had ended such investigation by sending me a letter stating I was no longer under investigation, and showed him evidence of this statement, Judge Brown lost complete control and bellowed, "It's fine for me to pay them, but it isn't fine for you to pay them?" On page 172, Judge Brown said a good 7 to 10 minutes later was still clearly personally consumed with annoyance directed at me because he personally pays income tax and I do not. Well, I guess you don't have any explanation for why I was in San Antonio, Texas last week, and they convicted 7 people for not filing tax returns. The jury did. So I guess that somewhere this last week, and they convicted 7 people for not filing tax returns. The jury did. So I guess that somewhere there is in this country somebody that thinks that you are supposed to file your tax return. Don't, Mr. Higgs? It is just not necessary. I have heard enough. I am going to write an opinion in this case, and I am going to publish it, Mr. and Mrs. Budrow, for the world to see. But I want to tell you now what it is going to be. You are going to lose. You finally come into a court where you are going to lose, and you are going to lose bad. But I want to tell you why. This is a judge talking. Okay? When you file bankruptcy, it is not a free ride. It is awfully obvious that you two folks have been living in very fine homes here in Senatobia, in Connecticut, and in California, especially in Connecticut and Senatobia, worth hundreds of thousands of dollars. That you have the benefit of a wonderful lifestyle, furniture, antiques, travel, basically doing what you want to do, but that you have been able to do that by secreting your assets from your creditors for a long period of time. You have been hiding your assets from your creditors for a long time. You have been dealing in cash and by not having bank accounts. Judge Brown ranted at my wife and me for what seemed like a very long period of time, forcing us to stand there, being berated, accusing us of wrongdoing over and over again. It's a fine way for a United States judge to act. Finally, he told us he was giving a family business that belongs to the family trust to the trustee. See, that's what he's after. They're after their money. It is not yours. It belongs to the trustee in bankruptcy, and I hope he takes it over. I don't know, but if he doesn't want to do it, I will find somebody who will. How's that? For fairness and impartiality. Another thing that I am going to perhaps do, I am going to ask the United States trustee to investigate this case and to determine whether this case now should be transferred to, guess where? Connecticut, so that perhaps that court might decide whether they should appoint a trustee in Connecticut who could more easily pursue your assets and your business activities. Yes, sir, you have a long road ahead of you, Mr. and Mrs. Budrow, and it is not going to be pleasant. You didn't play the game right, and you are now going to pay the price. And I hope it is a heavy payment. Nice guy, huh? What's his name? His name is Brown. Let's go back and get his name. Put it up on the screen. And just let everybody know that this man is not fit to be a judge. I know so many Browns. He's Judge Brown. William H. Brown. Judge William H. Brown, bankruptcy judge. As pro se litigant, Until recently, my wife and I had no idea that it was even possible to motion a biased judge to recuse himself. This year, during one of the last hearings in this case, Judge Brown made it clear that he still harbors the same bias and animus against us. Quote, Brown, there ought to be some serious settlement discussion between your folks. Serious. The trustee may have been given a gold mine here. Yeah, that's what they're asking. Now, this is not bankruptcy property, but this judge and the trustee, they want to get their fingers on it. Don't you understand that's what courts is all about? I told you about the New Rochelle City Court. All of their interest is bail and bonds and increasing bail, and have you paid bail, and have you paid fines. That's all they're interested in, money. And this is true right here with this bankruptcy court in Tennessee. Based on the foregoing, it is my belief that the pervasive prejudice and bias in favor of the trustee plaintiff and against me and my personal beliefs is so deep-rooted that I can no longer even hope that I might receive a fair trial in Judge Brown's court. It has become so abundantly clear that Judge Brown cannot and will not judge my case on the merits and according to law, but will decide them adversely and regardless of the law in favor of the trustee and against me, that there no longer exists even a single glimmer of hope of Judge Brown having impartiality of judgment in this case. I firmly believe no reasonably prudent person could possibly stand in my shoes and believe that they would have any chance of receiving a fair trial in Judge Brown's court. Further affiance saith not. William W. Budrow. It is so pitiful what they have been through, these people. And that there's no courts left to help them. Just greedy gangsters in courts. The next appendix continues the names of more crooks, crooked lawyers, crooked trustees, and corrupt judges. Boyce F. Martin, Jr., Chief Circuit Judge, 6th Circuit. Allison Batchelder, Circuit Judge, 6th Circuit. Danny J. Boggs, Circuit Judge, 6th Circuit. Eric L. Clay, Circuit Judge, 6th Circuit. R. Guy Cole, Jr., Circuit Judge, 6th Circuit. Martha Craig Doherty, Circuit Judge, 6th Circuit. Ronald L. Gilman, Circuit Judge, 6th Circuit. Cornelia G. Kennedy, Circuit Judge, 6th Circuit. Gilbert S. Merritt, Circuit Judge, 6th Circuit. Karen Nelson Moore, Circuit Judge, 6th Circuit. David Nelson, Circuit Judge, 6th Circuit. Alan E. Norris, Circuit Judge, 6th Circuit. James L. O'Ryan, Circuit Judge, 6th Circuit. Eugene E. Seiler, Jr., Circuit Judge, 6th Circuit. Richard F. Sir Heinrich, Circuit Judge, 6th Circuit. Bailey Brown, Senior Judge, 6th Circuit. Leroy J. Conti, Jr., Senior Judge, 6th Circuit. Albert J. Engel, Senior Judge, 6th Circuit. Ralph B. Guy, Senior Judge, 6th Circuit. Nathaniel R. Jones, Senior Judge, 6th Circuit. Senior Judge, 6th Circuit. Okay. All right, guess that's right. Damon J. Keith, Senior Judge, 6th Circuit. Robert B. Krupansky, Senior Judge, 6th Circuit. Pierce Lively, Senior Judge, 6th Circuit. Harry W. Welford, Senior Judge, 6th Circuit. William O. Bertelsmann, Chief United States District Court Judge in the 6th Circuit. Kentucky Eastern. And then there are about 8 more on this page, and 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 8 more on this page. And 8 more on this page, and 8 more on this page. The last one on this page is Defendant John P. McCullough, is a United States District Judge in the 6th Circuit, Tennessee Western, with a business address of 167 North Main Street, Memphis, Tennessee. And there's about 5 on this page. And the last page of this paper is the issuance of service in non-prisoner paid pro se complaints. And it says consistent with the 6th Circuit Court of Appeals opinion in McGore versus Rigglesworth. And it's Administrative Order number 9701. And this is signed by Julia Smith Gibbons, Chief United States District Judge, Memphis, Tennessee. And this is horrible. Ordered that service not be issued upon the filing of a non-prisoner pro se complaint when a filing fee is paid pending review of the complaint's merits under 28 U.S. Code Section 191, Section 1915, that's the Informa Pauperis, provides that whether or not a filing fee is paid, shall dismiss the case at any time upon the court's determination that any of the 1950 E2 provisions are met. It is further ordered that upon the filing of a non-prisoner pro se complaint, when the filing fee is paid, the clerk's office will promptly direct a copy of the complaint to the pro se staff attorney's office for priority screening and will refrain from issuing summons to the plaintiff for service on the defendants until instructed to do so by court's order. Done and ordered this 30th day of May 1998 for the court, Julia Smith Gibbons. Isn't that awful? That's unconstitutional, and she should be sued for that. They've already sued her. Okay. got to know that this is the end. Sure that you will want to know about, because it's your world and you don't want these things happening in your world. And first of all, here are some chats with Glendora, telephone chats. Cablevision Public Access sort of falls apart when Amy Van Horn isn't there. I'm on hold now for her.
Yeah. Well, you know they answered, though. This is Pro Se, and they actually answered.
Pro Se, Southern District of New York.
Yes, please. Can you tell me the status of Glendora versus Sylvan?
Can I tell you what, ma'am, the status?
Yes, please.
May I have your docket number?
That's what I'm looking for, a docket number and a judge.
So you submitted the case?
No, I did not. It was transferred from Philadelphia.
Okay, let me see if,
Thanks. How are you today?
I'm doing fine.
Weather's good, huh?
Mm-hmm.
What's your name?
My name is Alicia.
How do you spell it?
Your case is still going under judicial review.
What's that mean?
That means it's being reviewed by the court.
What's it? By what court?
By the court, by the Southern District Court.
Why don't I have a judge, and why don't I have a case
Went
number?
under review. It's like so many cases that we get here a day.
Well, like you got this case 2 months ago.
Yeah, we got cases about several months ago, too.
I don't think you...
Well, it goes under review. I have no...
Okay, how do you spell your name?
My name, the spelling is
Yes.
A-L-I-C-E-A.
Oh, Alicia?
Yes.
Okay, that's pretty.
Thank you.
All right, I would say that Glendora is complaining that the court is being close to her, and somebody ought to take care of that case. Toot sweet. Please pass on my complaint.
Okay.
Thank you, Alicia.
You're welcome.
Bye-bye.
Bye-bye.
This is the Lane Brain United States District Court, District of Detroit, 5005. This is March the 23rd, Friday.
Good morning, clerk's office.
Oh, good morning. Can you tell me the status of Glendora versus Levin?
Hold on a second.
I have a case number.
Hold on. I want to get in there.
Okay.
Okay. For case inquiry 1. Okay. Case number.
Okay, 00.
Is there a number 2 in front? No. Was it for Detroit, Port Huron? Where's it for?
Don't know. 00
Hold on.
73.
Hold on. Is it civil?
Yeah.
Okay. 7 what?
735
735
49
73549.
in the year 2000.
Okay.
Anno Domini.
So it's Glendora versus Levin.
Good for you.
It's an ISP case.
Yes, it is.
History. All right. There's 4 documents in there. One's an order to waive prepayment for the file fee, and the second one's a complaint, and an order to show cause, and an answer to.
Very good.
Yeah. So
Said nothing else, huh?
nothing else that I can see here.
No. What's the matter with Rosen? Get off his butt, because that was made in September 23rd sometimes.
The last document was filed on September 25.
Yeah. And what's he doing? Is he working? Is he out on the golf course? Where is he?
Yeah, you kind of wonder, huh? Let's see what this is. This order. Well, you know it here. Answer by plaintiff to order for plaintiff Glendora to show cause why within 10 days from the date of this order.
Yeah, well, she did that.
Dismissed, okay.
Yeah, she did that.
That's it.
That's good, thanks. What's your name?
Carla.
How do you spell it?
C-A-R-L-A.
Oh, how pretty.
Thank you.
That means a female Carl.
There you go.
A daughter Carl, or a sister Carl or something. So do you know that behind every successful man there is a proud wife and a flabbergasted mother-in-law?
I don't know. I never had a fight. My mother-in-law was kooky. Sure, she still is, but she's not my mother-in-law no more.
Oh, okay. Listen, so send a word up to the chamber. I think this is ridiculous. You can't close the courts to an American citizen.
Okay, so you want me to put a note in Rosen's box or something?
Yeah. Tell him to light a match under him.
Okie dokie.
Okay.
Alrighty.
Thank you very much.
You're welcome.
Bye-bye.
Bye.
Leave a message for Jeff or Pat, so it's beep, and we'll get back to you as soon as I said bye.
Patricia, I think that your last message was wonderful, and it was at least 2 weeks ago. And I apologize. Franklin fell, and he is not ambulatory. It takes a huge amount of time to care for him, plus the fact that the work that he used to do, I have to do now, plus the fact that I rescued a doggie, another doggie. And he takes an inordinate amount of time. He's an awfully cute little puppy, and he's adorable. So, I want to thank you for all that you did. It sounded wonderful. I want to know what time the programs are on, what channel, what day, what hour. And so, the next call, I will call dumb CTV and see if I can get some information from that. But anyway, I wanted you to know that what you did was appreciated. You got the programs over there, and you got them started to be transferred to DVC Pro. Okay. Oh, did you know behind every successful man is a proud wife and a flabbergasted mother-in-law? Take care.
That's Staten Island, Patricia Brady.
We're calling dumb public access TV or Staten Island.
Community television, can I help you?
Oh, hi. Can you tell me when a chat with Glendora is on?
What's the name of it? The chat with who?
Glendora.
Okay, one moment, please.
Thank you. I'll turn off the recorder.
Hello?
Oh, hi, Jeff. How are you?
Good.
Is your mother there?
No, she's working today.
Well, tell her that I called the TV station and they are cable casting the tapes. I am very pleased and I am very grateful.
Okay.
Will you tell her that?
Sure.
And do you know that behind every successful man is a proud wife and a flabbergasted mother-in-law?
I didn't know that.
Okay. Take care.
Okay, well,
Bye.
bye-bye. Public access, Bob speaking.
Hi, Bob. It's Glendora. Is Amy there?
No, she's not in yet.
Oh, okay. Do you know when she scheduled the 10 programs I brought in Tuesday?
Hold on for a second.
How are you, Bob?
All right, how are you?
Good. Do you know that behind every successful man is a proud wife and a flabbergasted mother-in-law?
Hold on for a second, hold on.
Okay. It's a good boy. Ain't you a good boy? No, he be good boy. He be good dog. Yeah. He good dog. He's a pretty dog. He's a pretty dog. He's a good dog.
Glendora, you said you brought them in Tuesday?
Yeah, I brought them, excuse me, I misspoke. I brought them in Wednesday and I met Mary, her friend.
Okay, hold on for a second.
Okay, thanks.
I see the tapes, I'm just not sure if they have been scheduled.
Okay, what time do you expect Amy?
Amy is having a bit of car trouble.
Oh, God bless her, yeah.
Yeah,
Oh,
I'm hoping she's in by 10:30.
isn't that awful?
You know, it's always, because you know why? Because there's nothing going, everything was going fine.
Yeah.
It always creeps up on you like that.
Yes, I know. I hate car trouble.
Yes.
Oh, okay.
Alrighty?
Yes, I appreciate that very much, Robert.
Okay, I will pass along your call.
Okay, and I hope to see you next week.
Alrighty then.
Bye-bye.
Bye-bye.
Hi, you've reached 234-2228. No one's available to take your calls at present, but if you leave your name and number, we'll get back to you shortly. Thank you.
Hi, Lori. This is Glendora. I apologize to you for not getting back to you. My partner fell, fall number 5, from the kitchen to the bathroom only in the hall, and he's not ambulatory. And the poor guy is in pain, but he won't take an aspirin because he thinks it makes his mouth feel funny. But he's better today. This happened on March the 9th, Friday, and it takes a lot of time to take care of him. And then the things that he used to do, I have to do. And then number 3 is I rescued a dog, another dog. He looks just like Midnight. So let me tell you that it's not Jim Cahagan. Jim Cahagan is your sponsor in Rockland. It's Gene Crescenzi, like the crescent moon, Gene Crescenzi. And let me give you Gene's number. He is the one who's said he sent a friend to Washington, D.C. to look at the judicial financial statements and looked at Calabrese's. And let me find Gene's number for you. He's your sponsor also in the Bronx, Gene Crescenzi. Hold still. That'll take me a while. Everything is in a terrible mess. Awful mess. And I feel like Job, how much more is going to be laid upon me. Where can I find Gene Crescenzi's number? Oh, and Lori, while I'm looking for Gene Crescenzi's telephone number, I think there are holes. I know there are holes on the public access channel, and it is all right with me if Cablevision just repeats my programs and fills up those holes. I wouldn't want programs repeated that were in the prime time spot, or because I haven't got a new program ready. I would not like a program repeated on that basis. But I think on the basis of having empty holes, it's much better to have programming there. And so, therefore, I would like to leave the tapes. That was so nice of you to pick them up. But I would like to have you leave the Chat with Glendora tapes at Woodbury, and I will pick them up. In fact, I can even pick up yours at Woodbury, so that Woodbury would be off your list. You do Hauppauge and Riverhead. Because I asked on Wednesday, I called up, and I happened to be editing. I had to edit twice this week. I got to tell you about that. A woman came in.
Yeah, let me tell you about that while I think of it. A woman came in Tuesday. Her name was Goldberg. Now, you've heard of Rube Goldberg? Well, this was Rube Goldberg. It was about the rudest person I ever saw. And after 3 or 4 lashes at me, then I decided I would just go about my business and not have anything to do with this woman. And so she asked me questions, and I just would not answer her. And she asked me other questions and other questions and other questions. That really got to her, because she was so arrogant and so sure that she was Napoleon. And so I just didn't answer her. And I think that's the best way to do when somebody comes at you and is rude like that. Just ignore them, because that's the one thing they can't stand. You know, it goes back to the old psychology principle, Psychology 101. You can hate me or you can love me, but don't ignore me.
Pronto?
Hi, Gene.
Yeah.
Wait a second. I'm writing down your telephone number, 364. It's in my auto dial. That's why I don't know.
Good. 364-6486.
Just a second, Gene. 364-6486. Lori Galgano wants to go after Calabrese, and she'd like to have an affidavit from you that you found out on his financial statement that he put down he's worth $28 million.
Okay.
Okay?
Well, I didn't know. Was that the amount that it was? I thought it was 36 million something.
No, you told me $28 million for Calabrese. Well, am I wrong?
Well,
Or is it? Okay, then do it by your recollection.
a month ago.
Okay, then okay, and that Bader Ginsburg was 23 million.
Well, something like that, yeah.
Okay, well, yeah. Would you just send an
Well,
affidavit?
I'll do an affidavit to that effect.
Okay, will you send it to Lori Galgano?
Yeah.
24.
Wait a minute. Let me get a paper so I can write this down.
Why? Sure.
President Bush has announced that he's no longer going to accept the
fraudulently procure approval and ratification from the Senate Judiciary Committee. Are nothing more than a bunch of shysters, but it's not enough. What President Bush should do is open an investigation on the mischief, the organized mischief and dishonesty that is practiced by this bunch of shyster lawyers now become judges, and in order to assure the United States people of honest courts. Now, his own election is proof of the fact that the judges have usurped the right of the people to elect a president in a democratic, and of course the fact that he had to go to court and he was always being yo-yoed by judges either in the state courts or in the federal courts. And finally, the final yo-yoism was from the bunch of gangsters, the shysters in the Supreme Court of the United States, who, for whatever reason, they couldn't tolerate the unmasking of the fact that the judges were electing the president and of the people. And so that would be something to consider, and it's not enough to just get rid of the Bar Association approval procedures, but there should be an investigation on what the judges is doing right now. And of course, I could give him a whole bunch of cases. There's the case of Giselle Weiskopf. There's the case of Albina Goldbetter. There's the case of your various cases of Glendora, the Glendora cases, and of course there's my so-called disbarment or suspension in the federal courts. I'm only suspended. Let me see if I got anything more to say.
No, I think that's superb, and I agree with you 100%.
So, well, okay. So that's my lecture for today.
Excellent. Have you ever heard of the Michael Brown School of Law? It's on the internet.
Michael Brown School of Law? No, I've never heard.
Oh, are they good at fighting back judges, crooked judges? Oh, are they good? They are so good. They have seminars, and they teach people how to fight these crooked U.S. judges and court and state judges. They have seminars on it. They teach them all about U.S. Code Section 1983 and 1985 conspiracy. They teach them about civil recall. They teach them about, it's good stuff.
Well, I'm glad to hear that.
Yeah, he's made a series of videotapes, and he sent me piles of them. I got the first two on the TV last week.
Is Michael Brown?
His name is Michael Brown on the internet, www.so-and-forth.
When I get my internet working again, somehow or other, I did something wrong with it.
Okay.
I've got to have it reprogrammed or something, or change my password.
Okay.
So I will keep that in mind. Michael Brown.
Yeah, the Michael Brown School of Law. Boy, is he good. He's good. He's, and he teaches what they found out what they do with pro se complaints, and he's good. He's really, and he's particularly good at filing 372C1.
Incompetency.
That's right. Conduct prejudicial to the what is it? The expeditious and something business of the courts, the administration of the courts. What is it? Well, conduct prejudicial to the effective and expeditious administration of the business of the courts.
Right.
And so he's particularly good at that.
Right.
Yeah. So it's good to know that we got supporters out there. We got reinforcements.
Well, I think that we're responsible for the beginning this thing, because if it wasn't that we did this thing, we wouldn't. Now these people, it seems, if they got support, it seems they're being funded. Now that's important, because it has a downside. It's good news and bad news. What's bad news about when funding comes into operation is the fact that...
Well, honey, I didn't say they were funded.
Well, it seems that way from what you tell me. If they can afford to make copies and send out copies to...
Yeah. The next time he sends me a 372 complaint, I'll send it down to you.
All right.
And if you would sign it and send it. He just made one against Colleen McMahon, and you know how bad she is.
No, I don't know, Colin.
Oh, yeah, she came over from the Court of Claims, I believe, or the something court in Westchester County into the federal court in White Plains. You haven't heard about her, huh?
Well, I haven't, no.
Oh, okay.
Caroline McMahon,
Colleen McMahon.
McMahon.
Yeah.
I don't know her.
Okay, Gene.
Okay, well, thanks for the news that you gave me, and also I'm happy to hear about this Michael Brown guy.
Yeah.
From
Springfield, Missouri.
Springfield, Missouri.
Yes. And the seminar that they sent me tapes of was in Charlotte, North Carolina. Wasn't it? Was it Charlotte, South Carolina? Which is it? Anyway, Charlotte, South Carolina. Okay, Gene, did you know behind every successful man is a proud wife and a flabbergasted mother-in-law?
I had no idea.
Okay.
Okay.
Take care.
Right.
Bye.
Delivering Copeland's Lawn Sprinkler Service. Sorry that no one is in the office at this time to take your call. But at the sound of the tone, leave your name, phone number, please message. Someone will return your
Bill and Celeste Budrow.
Thank you for calling Constance and have a lovely day. All phone calls are being recorded and monitored for better quality. Thank you again.
Bill Budrow, I think your complaint, the civil RICO complaint, is superb, as I've told you. It's superlative. I have finished videotaping it, and I got the first 2 chapters of it onto up to the cable system in Nassau County, Long Island. Huge cable system, 450,000 subscribers, big stuff. And so I don't know if it's been cable cast or not. My contact there is late because of having car trouble. So I think it's superlative. And I'm happy to report I got the first 2 chapters of Michael Brown, all edited and handed into that same cable system. Okay, 914-949-9495. Do you know that behind every successful man is a proud wife and a flabbergasted mother-in-law?
Message in mailbox 1. Mailbox 1. Thursday, 1:50 p.m. Thanks. Hello?
Well,
Morning, Coach. End of messages.
People in church yesterday, Sunday, were saying prayers, and so I asked for one to be said.
prayers for Franklin Fuller Buell, that he be 100% well.
The minister came to see Franklin on Wednesday. That was nice. He sat with him for a long time. He is better. Franklin is much better. He really is. Thank you, God.
Even know what the law is? It's 47 U.S. Code 532 for least access.
Hello?
Hi, John.
Hi.
My name's Glendora. I'm on public access, Cablevision.
Right.
And I was looking at their least access file.
Right.
It's a law that they have to give the names and addresses of the people who inquire about it.
Right.
That's how I got your name. What is your opinion of their least access? My opinion is that it's really bad.
What aspect? I mean, I just got the agreement recently.
Well, that's what the agreement. Have you read it?
I haven't read it in full detail yet. I'm
Okay.
waiting to see it with my partner.
Well, here's what I think. Well, first of all, the rates are outrageous. They won't let you go on less than 13 weeks, right?
Right.
And it's something like over $3,000.
Right.
Now that's a lot of money, and you've got to have a lot of sales to make that sensible.
Right.
And then the other thing is that when you get to read the agreement, it is so imperious and so Napoleonic
Right.
and so regimented, and it just makes the hair of any American bristle. And so that's what I don't like about it.
Okay, yeah, no, like I said, I haven't read it in full detail yet because I'm waiting to, I'm supposed to be doing something with a bunch of people and we haven't got to sit down yet and talk.
Yes. Let me give you my number.
Okay.
914
914
949
949
9495.
9495.
And I have another number, 631
Okay.
425
Right.
0304, and my name is Glendora.
Okay.
I've been on Cablevision Public Access ever since 1993,
Right.
and I don't like what they're doing in public access either.
Right.
And also, I think that they should tell us who has been on public access, what time slot, how much money did they pay, what was their return,
Right.
and the other thing is, did they have any comments or complaints or anything like that? That's
Right.
Okay, John, I'm calling as many people as I can to see if their opinion is of it, and you're not quite ready because you got to talk it over.
Right. Right. So,
Okay.
but, yeah, I'll give you a call once I speak with everyone.
Yeah, good.
Let you know.
Okay.
All right.
Yes, what do you call a miniature guppy?
What?
A microfiche. Okay, John, thank you so much.
Problem. Take care.
You too, bye. Glendora, and I am on public access Cablevision in Long Island. And I saw your name as somebody who inquired about least access. And I wanted to know what you thought of it. I do not think much of it. I think the agreement is stringent. I think it's awful high, $3,000. I think it's awful that they make you buy 13 weeks. You can't buy less than that. And I think that the public access agreement is undemocratic, un-American. I think it's Napoleonic. So I'd be interested in your opinion. My number is 914-949-9495. The list of people who have inquired about least access is just as phony as the shareholders list. The people don't have telephone numbers. You can't reach them to talk to them. And it's just a fake like the shareholders list. Oh, Richard.
Glendora.
Yeah, what do you think of least access?
Too expensive.
I think so. And they make you sign for 13 weeks.
Least access? That's why it's used for least.
And
50 states.
well, that's good.
In fact,
Michael H. Brown.
stay off the top of your head. The odds are about 80%. I've been there, and I could even tell you about the case I fought in.
Oh, that's great.
You want to try it? The other states in the 8th Circuit, Missouri, Missouri,
Oh my goodness.
Iowa,
Good. Really?
Dakota,
Yeah.
North Dakota,
Good.
Minnesota.
Good. Phenomenal.
I mean, out of 8 states in the 8th Circuit, I've had cases in 7 of them.
That's great.
So,
I think you're terrific. You are the great one. I love what you do. Okay, that's the point of my call to tell you that I'm jubilant that I got 2 Michael Browns done. And what's this Erwin Rommel school? Who's that?
that's me.
No, you're Michael Brown.
Well, that's true, but see, here's what happened. About 9 years ago, I was up in Minnesota. I gave a seminar up in the northern part of the state. And I went down to Minneapolis the next morning. I didn't get any sleep that night.
Huh.
And so I was kind of punchy when I started. And I was basically showing people how to apply military tactics to courtroom proceedings because those judges are the enemy. And so I just kind of wandered out there. I was about, I was trying to wake myself up. I said, ladies and gentlemen, welcome to the Erwin Rommel School of Law. It was a joke. And it stuck. In fact,
Who's that, the General? Rommel?
yeah, the North Africa.
Yeah, North Africa, Rommel.
Yeah, and what happened next is that somebody, I forget exactly what happened, I did an interview for Acres USA, and I just mentioned that. And this literary agent called me from Los Angeles and said, I want you to do a book on the legal system. I said, what do you want me to call it? He said, the Erwin Rommel School of Law. I said, okay, so I did. But the whole thing started as a joke, though.
Oh, okay, so then that's you, huh?
Yeah, well, actually, I started it. Peter Simpson calls his book business the Erwin Rommel School of Law, and he refers to me as the field marshal. I really don't. I don't call it anything. I mean, I just.
You're the